All rise. Second Judicial District Court of the State of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. All right, this is the time and date set for the continuation of the order to show cause hearing why the writ applied for writ of mandate should not issue. Case number is CV 20-00755. Case name is Amethyst, Payne and others versus State of Nevada, Department of Employment, Training and Rehabilitation, which we will refer to as D.E.T.R. I'm Judge Breslow, calling in from Washoe County, Nevada. We are proceeding this morning pursuant to Nevada Supreme Court Rule Subpart 9 and various administrative orders of Nevada 2nd Judicial District Court and the Nevada Supreme Court, which are a response to the COVID-19 pandemic and which allow hearings like this to be conducted through simultaneous audio-visual means. This hearing is open to the public through the Zoom webinar platform, which can be accessed through the court's website. The court is also live streaming on its YouTube channel for those interested in today's proceedings. The court is aware of other requests for access, so it's no doubt also available on one or more media outlets' websites. Starting with the court's staff, would you please identify yourself, Ms. DeGaynor, and where you are calling in from?
Yes, Your Honor. Amanda DeGaynor, court clerk from Washoe County, Nevada.
Thank you. Ms. DeGaynor, you broke up a little bit there. So we'll make sure that we keep an eye on the technology so that everyone can hear and see properly, which, by the way, if there are any issues with that, please get our attention and we'll recess to allow people to reconnect fully. Next is the court's certified shorthand reporter, Ms. Zinn. Would you please identify yourself?
Isolde Zinn, Washoe County, Nevada.
Thank you. Ms. Zinn, in case I forget to later, please, the court is ordering a typed transcript of today's hearing at your earliest possible convenience and a rough draft of today's hearing to be delivered to the court even sooner with copies to each side. Starting with counsel for the plaintiff, Ms. Jones, would you please identify yourself and where you are calling in from?
My name is Leah Jones, and I'm calling from Washoe County, Nevada.
Thank you, Ms. Jones. Mr. Thierman.
Mark Thierman, also from Washoe County, Nevada.
Thank you very much. Deputy Attorney Generals, let's start with Mr. Ott.
Greg Ott calling in from Carson City, Nevada.
Thank you very much, Mr. Ott. Mr. Whitney.
Robert Whitney calling in from Clark County, Nevada.
Thank you very much. And then would you like to identify any of your client representatives who are participating this morning?
Yes, Your Honor. With me here in Carson City, we have Kimberly Gah, the administrator of the Employment Security Division, the chief economist, and Troy Jordan, counsel for the Employment Security Division.
Very good. Thank you. And for those of you that were just identified, feel free to turn on the video feature if you'd like to, but you certainly are not ordered to. Okay, well, let's get right to it. Much to discuss. We all are aware that Friday afternoon, let's actually have him identify himself for the record as well. Mr. Guanasso.
Yes, Jason Guanasso, Special Master appearing in Washoe County, Nevada.
Thank you, Mr. Guanasso. Didn't mean to overlook you. Okay. We're all aware of the comprehensive report Mr. Guanasso prepared, along with his very capable staff, with what appears to be remarkable cooperation from both sides here. The report was filed Friday afternoon, itself some 300 10 pages. The appendices as well in the 4 figures. Those are over here on the court's desk. It shows remarkable effort in a short time period, and both sides are to be thanked and commended for their very workable approach to assisting the special master with his task. In a moment, I will ask the special master to provide a brief overview of his factual findings, somewhere in the neighborhood of 10 to 15 minutes, and have authorized him to use his screen share feature if he'd like to direct our attention to some of the more important pieces of information that he uncovered. Before we do that, though, I want to take up an issue with plaintiff to make sure we are still good to go. And by good to go, I mean the court continues to have jurisdiction and the plaintiffs continue to have standing. Mr. Thierman, it's come to the court's attention that all but one of the named plaintiffs have had their benefits begin. And then you can respond whether you believe that's factually accurate or not. And if so, does the court still have a ripe case for adjudication? In addition, in the common parlance, this case has been referred to as a class action lawsuit seeking to have the court order D.E.T.R to do something or stop doing something that the law otherwise requires. So we're all clear, and anyone listening understands the procedural posture of the case. This case is not now a class action lawsuit. It has not been certified by the court as a class action lawsuit. There has not been a motion made, an opportunity for a response. The court has made no findings on the proprietary of this case being a class action. That being said, is the court aware that this case and the decisions of the court will have far-reaching ramifications on thousands, potentially tens of thousands? Of course. But this is not yet a class action. And so the rules that apply to class action cases, jurisdiction, standing, things like that really are not directly in place. So with that, Mr. Thierman, does the court still have authority to go forward? If so, why?
Yes, Your Honor. First of all, the doctrine is, I believe, capable of repetition yet evading review. I can put in 10,000 plaintiffs, and each one maybe get paid off before this court can render a decision. There is a problem in this timing of things. The moment you measure jurisdiction is the time the case is filed. It's not a question of mootness because there is adequate representation. My plaintiffs want to go forward. We still have a claim for interest, by the way, on the writ. We still have a claim for attorney's fees. So we have not had a decision on those issues. And we have one plaintiff still that's has a claim outstanding. Whether it's viable or not is irrelevant. It's still a claim.
Well, let's assume D.E.T.R paid that claim today.
Yeah.
Would that affect
No, because again, it's conduct capable of repetition yet evading review. That is the standard. Obviously, I can amend in at any time all the, I don't know, we have 5,000, 3,000 emails for people who say, I want to join. I kind of take issue with the idea, yes, it's not a certified class, but it's a B2 class in the sense that this is conduct that, unlike a B3 class where you have monetary damages and you have all these superiority and all these other issues, a B2 class really is a class where we're asking for all the same relief, and what D.E.T.R does to one presumably affects everybody. And again, the purpose of this lawsuit is systemic relief. The whole point here is systemic relief, and squeaky wheels get the most attention, but that doesn't help the 139,000 people who haven't been paid yet. It is a viable class action, or a viable, at least putative class action. And the reason I mention that is because I'm going to now get about 1,000 or 2,000 emails telling me I want to opt in. How you decide affects everybody. And, I don't want to get bogged down on individual facts. It's the systemic facts that are important. So for that reason, I say you do have jurisdiction. Even if these people were paid off in full, there is a pending claim for interest. There is an outstanding request for a writ, and you measure jurisdiction at the time the complaint's filed. Otherwise, you could always moot out any class action by simply paying off the plaintiffs. And that's not the law. You can't do that.
Okay, thank you for your position on that. Who would like to respond from the state? Mr. Ott, Mr. Whitney?
Deputy Attorney General Greg Ott, I'll respond, Your Honor. First of all, apologize for the screen. To prevent the feedback, we're using the conference room audio. So my picture is there, but not necessarily the one that comes front and center. So apologize for that.
You're doing fine. Thank you.
Okay. What Mr. Thierman just said, I think is telling is not wanting to get bogged down with individual facts. This is a court where we have to deal with individual facts, and he has to vet individual plaintiffs and make sure that they are valid people. We know that there is rampant systemic frauds. We know that there is Nigerian rings targeting P.U.A programs. And for him to say that there's 139,000 people out there, that is a vastly different allegation than there are 139,000 claims. Claims are not presumed eligible. We know that very clearly from the Department of Labor. There are still, I believe it is 2 of his claimants have not been paid, but the vast majority are moot, and he should not be allowed to continue presenting claims, emails, and evidence from people who are unsubstantiated. We don't know if they're actual people. We don't know anything about these people. So I push back on the fact that just because he thinks that there is a problem, he is allowed to put in evidence from unsubstantiated sources without any sort of verification or foundation. I'm thinking specifically about the filing filed this morning, which we don't know where it came from. There's no names on it. There's nothing in there to show that it's a legitimate filing. It makes it impossible to respond when we know that there's rampant fraud issues out there. So
okay, well let me hit the pause button on that last piece, because what you're referring to are the supplement that was filed just an hour or so ago that identified more recent guidance from the Department of Labor with respect to the United States Supreme Court case of Java and how the court's ruling in that case might impact states' administration of the Pandemic Unemployment Assistance Program. That's A. B is the second piece of evidence or the second submission, which was some screenshot and communication from a person who the plaintiff represented believed they had an application altered in a material way without their permission. So we can talk about both of those if we need to, particularly the second one, if we need to at a later time. But with respect, I don't need a response to what you just heard, Mr. Thierman or Ms. Jones. The court concludes as a matter of law that it does have jurisdiction to go forward. The plaintiffs continue to have standing. Not exactly for all the reasons Mr. Thierman said, but because at least one of the allegations here is that the state is abusing its discretion or acting arbitrarily and capriciously by stopping payments to people who apparently have had payments begin. And so to the extent that some of the named plaintiffs have had their claims reviewed and benefits have begun to be processed to them, to the extent that they may be subject to similar treatment as alleged that others have in the complaint, and for other reasons, the court finds that this case is not moot, that they have standing to proceed, and that the court maintains jurisdiction. All right, let's move on. Mr. Guanasso, once again, the court thanks you and your staff for the substantial efforts that went into the investigation and the preparation of the very comprehensive report. It's clear to the court that this has had both a personal and professional effect on you by virtue of the manner in which you wrote the report. And the court understands and appreciates that. Emotions are high throughout the state, both within and without of state government, and with respect to claimants, their families, and those that care about them. But for purposes of your presentation now, if you would please make a 10 or 15 minute overview of the important points that you believe came out of your review of the information that was presented to you, that you sought out, and that the court asked you to look into. So, Mr. Guanasso, please proceed.
There must be an evaluation of best interest.
You're going to convince me to hold your client in contempt.
Raise your right hand, face the court clerk to be sworn.
These judges get contempt from all the time.
I find you in contempt. I am going to incarcerate you.
Pursuant to that Supreme Court ruling, your death penalty qualified.
This is the time set for your hearing on custody.
Please put in writing your concerns or objections.
Thank you, Your Honor. What I'm going to do is share my screen with you, with your permission, and take you through the high points of the presentation, or the high points of the report. Can you see that? Okay. Do you see the first slide there? Hello.
I gave you the universal thumbs up. In
Okay.
Zoom world, that means good to go. But yes, I can see it just fine. Thank you.
I'm a little bit blind here. So in any event, in order to, the key to really navigating this report is to understand how it's structured. The report really starts with putting the questions presented by the court into the context of the global pandemic. It then provides an overview of how Nevada's unemployment system works, both pre-pandemic and post-pandemic. I think it's important to understand in that context, the people and the processes subject to the unemployment crisis caused by the government's pandemic policy. And so I spent some time laying that out for the court and highlighting some of the key people who administer these programs in our state. Then, because the question of mandamus really goes to whether or not the state has done something the law requires it to do, I thought it would be helpful for the court to see a timeline of D.E.T.R's response to the crisis. So I provided a section on that. And so what you're seeing is kind of a funnel. We start from a broad overview, and then we're slowly working down this funnel to get to the court's questions. In that regard, the court was really interested in data, and so we spent time working with D.E.T.R to provide the relevant data regarding P.U.A claims. And then we went into the specific status of each of the petitioners. And then we looked at the potential class of workers. If this court were to find, that there was a class action, what would that class look like? And or if you didn't find a class, but the court wanted to know the widespread impact on people across the state, this section would provide that information. We also took a look at, as you can see, as we move down the funnel, we took a look at we took some time to ask questions about what other states were doing. And so we provided a summary for you of what's happening in other states who are struggling with some of these same issues post-pandemic and with regard to the government policies related thereto. And then thanks to the efforts of Administrator Gaw, I was able to present some questions to the Department of Labor directly and provide those for the court's edification. And after having provided context, background, data, and narrative to the court up to that point, I then provided the court with short answers to the specific questions that were presented by the court. This was followed by the several questions I submitted in writing to both D.E.T.R and to the petitioner's attorneys. Finally, the report identifies bottlenecks and fractures in the system and offers some proposed recommendations. Now, please note, this general outline, Your Honor, I provided this outline to the parties probably a week ago Saturday before I began writing, so that they could see what I intended to cover and the information that I needed from them. This also provided the parties with an opportunity to provide suggestions for topics and questions that they thought would be beneficial to the courts and the special master's inquiry. So with that being said, let me take a few moments to go through some highlights of the report and discuss the bottlenecks and fractures identified in the report and the recommendations I provided to the court related thereto. With respect to the global pandemic, I just wanted to, the one graphic that stood out to me most of all the things that I looked at was this graphic. And I think it should be of interest to the court as well, because when you think about economic earthquakes and the resulting tsunami of unemployment claims that occurred here with regard to COVID-19, I want to put that into historical context. Right here, this is 9/11. Right here is the Great Recession with regard to unemployment claims. And up here, Your Honor, this is COVID-19. There is no system devised by man that I'm aware of that could handle that many unemployment claims in that short a period of time. In Nevada, for context, Nevada was hit harder than than the rest of the country. Here's where Nevada stands, and then here's where the rest of the nation stands relative to unemployment. So with that context in mind, it's important to see that pre-pandemic, the D.E.T.R had approximately 186 people working in the Employment Security Division. Last year, they worked about 15,000 hours, 99 hours of overtime. Post-pandemic, as you can see, they beefed up their staff to about 303 people, pulling from other departments and bringing back retired people, and worked 193 roughly regular hours, but they logged, and since March, they've logged 30,000 hours of overtime. And here's kind of a breakdown of what that looked like month to month. And so I thought it was important for the court to know or recognize the human component of this from D.E.T.R's perspective. There are not a lot of people trying to do a heroic amount of work and trying to do it under circumstances that were literally impossible. I mean, in terms of trying to administer a program without having, problems occur, delays occur, and things like that. So I thought it was important for the court to understand, that context, that you both have, you have programs that have processes, and those programs and processes have to be managed by human beings. And as you can see, they didn't have, an unlimited amount of human beings to do the amazing amount of work that was presented to them in that short period of time. The court was interested, though, with regard to this process, the court was specifically interested in the user experience for the claimant. And so with regard to UI benefits, this is kind of what a user would log into. And so it just gives you a sense for, relatively speaking, the user experience on the computer is not too terribly difficult. The questions are relatively straightforward. If English was a second language for those who are applying, there may be some issues, with understanding the questions. And I believe they have a Spanish version of this. But this is the basic UI experience. Pre-pandemic, it's important to know when we talk about fraud, that fraud's not something unique to the P.U.A program. But pre-pandemic, the state of Nevada had issues with fraud and overpayments. And on page 54, I outlined some of those issues that they had prior to this year. Moving into the new programs, I think this slide really that you can find on page 70 really summarizes, the programs that are available and how programs are administered. You start with regular UI program, you move into the P.U.C, you then move down to the P.U.A program and then the FPUC program. But there's a cascading set of criteria for each program. And if you're not qualified for the first one, you move to the second. If you're not qualified for the second, you move to the third, so on and so forth. With regard to P.U.A specifically, individuals, in order for them to be eligible, must meet one of the COVID-19 related reasons listed in the C.A.R.E.S Act. They can qualify for P.U.A backdated all the way to February 2nd. They get up to 39 weeks of benefits, so on and so forth. I covered all that in detail in the report. With regard to the specific eligibility requirements, I think it's important for the court to recognize what those eligibility requirements are. Those are listed at page 80 and 81 of our report. And those eligibility requirements are fed into this electronic system that is making determinations as to who's eligible and who's not based on the information provided by the applicant. It's also important to understand who's not eligible for P.U.A. On page 81 of our report, I have a list of groups of people who are not eligible for P.U.A. Again, with regard to the user experience, I know the court was concerned about this, so we spent some time looking at the screenshots and the manuals that the department provides to the public. This is an example of the screenshot. When you first want to apply for P.U.A. benefits, this would be the first screen you would go into, and if you wanted to file, you'd click into that big button there that says file a P.U.A. claim. And then, you know, there's when you go to the next page, there's some beginning information, and then there's a specific list of questions that are asked that help the department determine whether you're eligible or not for P.U.A. Now, fraud, but P.U.A. is especially vulnerable to fraud, and so I think it's important for the court to recognize that, and that the department, as early as May 19th, began to recognize that, and they issued a statement to that effect, advising states to be mindful of attempts to defraud the system, and to be mindful of the fact that the states have obligations to maintain the integrity of the system. Here's one of the pages that one of the graphics we provided you kind of puts fraud in context. These are all unique applications that are outside the state of Nevada that raise suspicions about fraud. Here's, you know, unique P.U.A. applications within the borders of the state for a particular period of time. And then here's what, you know, these are applications outside of the state throughout the United States that that the department is reviewing. Now, I want to pause here for a second and just say, Your Honor, that there was some information about fraud that I could not put in my report because it was confidential, but D.E.T.R has offered to meet with the court and the and opposing counsel in camera in a private session to talk more about the details of its fraud investigation and what it's seeing and what its concerns are. I provided a timeline for the response, as I mentioned in my opening comments. We also provided data. I'm just going to flip through these really quick to show that, you know, we covered the data that the court wanted and provided specific.
Oh, excuse me. Go back to that last slide, please. So look at let's make sure the court understands. The column all the way in the far right, as of the date identified at the bottom, as of June 29, so 3 weeks ago, $250 million had been paid out by the state to applicants who qualified for benefits?
Yes, that's the data that I received from D.E.T.R. Yes.
All right, thank you. Please continue.
And then with respect to the denials, this is Nevada unpaid P.U.A. claims. And these are the reasons why there might be a denial or a lack of decision.
Well, let's talk just for a moment about the biggest 3 or 4 that you've checked there. And by the way, can you blow that screen up at all, or is that as big as we can get it?
I wish I had the IT expertise to be.
That's okay. What page of your report was that on?
This is on page 119 of the report.
All right, thank you. I'll grab that so the court can see it. I just want to make sure anybody interested in observing can read it. Give me a moment. All right, go ahead.
Yeah, so with regard to claims, there's some claims that are being investigated under what's called special project. That constitutes roughly 14,000 claims. There are other program eligibility issues.
Okay, stop right there. So for example, if the applicant appeared to qualify for so-called regular unemployment insurance benefits, that would act as a tripwire from proceeding under the P.U.A. program. Is that accurate?
Yes, exactly.
Even if they had $1 available, yeah. Right? All right. So did your investigation identify information, bottleneck approaches with respect to how to clear out that backlog of people who were stymied from obtaining benefits under the pandemic assistance, unemployment assistance program by virtue of these other programs.
Yeah, yes, Your Honor. I approached that question from a number of different angles and specifically addressed those questions to the Department of Labor because we were looking for ways. Like one idea that came up, while we were thinking about this was, could a person waive UI? Let's say they had $1 in their UI.
No, they can't. They cannot. The Department of Labor guidance is clear on that, right?
Yeah, it really is. So that wasn't an option. Could they relax the restrictions? No, they could not. I mean, there was really limited tools from a legal perspective at the disposal of D.E.T.R to eliminate that particular flag. The appropriate process, as I understand it, is you've got to exhaust your UI benefits before you can qualify for P.U.A. Which is unfortunate, but it's really the state of the law right now relative to how these benefits work together.
Well, the logic, as the court understands it, is that the federal money is available to assist you in your time of need only after you have exhausted the amounts that have been paid in for your benefit through prior employment, through combination of taxes taken out of your pay and your employer's contribution. So that has to be exhausted first. The issue, though, we'll hear Mr. Thierman, Ms. Jones argue passionately in a few minutes, is that D.E.T.R needs to do something to clear those out, to move those more quickly forward so that they no longer act as a blockade to obtaining the P.U.A. payments. Was there response that you saw from D.E.T.R to that? Was there data that you saw evidencing the response of D.E.T.R to that concern?
There was a confidential document I was able to look at with regard to how the actual program works and how it both identifies the flags and then allows for adjudicators and others to clear those flags. And there have been consistent and constant upgrades to the system because one of the things to put in the context too is that the P.U.A. program itself is brand new, and typically when you have a brand new program, you put it through a stress test before you put it out into the market, and you try to find all the bugs and issues that are in the program. Well, in this situation, they didn't have the time to put it through a stress test and to work out bugs and issues. They put out this program live, and then as issues were brought to their attention, they would make program changes, and then those program changes would then result in some problems being solved, but then other problems being created. As you mentioned, Your Honor, all of these, the individual plaintiffs, we looked at each of their files, and the parties confirmed that all but one was resolved. This individual did not qualify because of excessive earnings. And then the other individual is currently working his way. This individual here is working his way through the system to have his claim considered and potentially paid. I'll just work through those here. Here, I want to take just a moment of the court's time to enlighten the court on the communications from the claimants. We reviewed over 6,000 pages of communications, and then we categorized them in a database in exhibit or in appendix number 1. Just to give you an idea what that looks like in reality, those are the emails we reviewed from all the complainants. And I can't emphasize enough the expression of human suffering and despair contained in these documents really can't be understated. As the court has noted on a couple of occasions, there are real people suffering because for one reason or another, they're not getting benefits. And so we tried to categorize those reasons. And what we did is we set up a spreadsheet that, and this is Appendix 1 of in the materials provided to you, a spreadsheet that identified the main complaint, had some additional information about that complaint, had some specifics about their story, the claim type, the date was submitted, the P.U.A date submitted, the claim effective date, the work out of state issue, whatever the issues were, that either may have been a debit card was received but no money, funds received, but then stopped after receiving them. And so we tried to create a spreadsheet to really draw into relief for the court, really where these bottlenecks are from the claimant's perspective. And so once we got that data put together, we were able to identify trends. And one of those trends were, there were a number of claimants who identified themselves as first filers. These are the highest number of reports received concerning claimants, who had issues. And we interpreted this term, first filers, to mean P.U.A recipients who had filed their claims sometime during the week beginning in May 16th and ending in May 24th.
Well,
And
that's the first week, right?
Yeah, the first week. That's right.
First week after the program went live. And as the court recalls, many of the complaints, aside from in general, that other people may have experienced was, hey, how come people who later filed are already receiving benefits or otherwise having their claims reviewed and adjudicated when we were earlier in time, but we're being handled later. But your research reflected that the department recognized that there were issues in that first week, and they were doing their best, as I understand it, to whittle those down. Or do I have that wrong?
No, you're exactly right, Your Honor. They've recognized that there is a problem with that group of applicants, and they've been working to whittle that group down. This goes to the other big theme, and that is errors and glitches. And I want to pause here for a second to say, one, if there's a weakness in this report, it has to do with providing the court with understanding on how the IT works and what the problems are from an IT perspective. I did reach out to a consultant who's got over 40 years of experience building. He was the former owner of the Tandem Systems computer network back in the 70s, 80s, has been in the computer industry for years and years and years, and began to talk to him about some of these glitches and errors, because as an attorney, I don't have a lot of experience understanding kind of the nomenclature of IT and how the back end of a program works and where some of the errors and problems would be. But I'll tell you, with all the emails that we read, it was clear over and over again that there were glitches and issues with this program as it was being implemented. Again, because it was a program implemented without first being tested, there was, and without working out all the bugs. And so it's a program that's getting better, I suppose. Although I say that with some reservation, because I don't know like what's better, good, or best. Again, because I didn't really have the time to give an IT person who's an expert all the information he would need, then to give us an analysis of what would be required to fix these glitches and clear out some of the bottlenecks that are really driven by the software and the program itself, and not any other issue.
Okay, let me ask you a question there. I'm trying to recall in your report, it appears you indicated that perhaps one other state at least, or other states, had partnered with a technology information company to assist their state efforts in setting up a new plan. I don't know, like a Google or somebody else that deals with moving information around quickly. Did Nevada do that? Did Nevada have a chance to do that? Did Nevada politely decline the chance? Did any of your information reflect offers of assistance from outside the state? And if so, what the state's response was?
Yes, Your Honor. There was no evidence that there was offers of assistance from the private sector here in Nevada. And, Administrator Gaw, in making decisions about what to do, I think evaluated the current system under the UI that administered the UI program, determined that system could not administer P.U.A. and UI at the same time. She looked to other states and determined that other states were using this particular software company and its software to deliver benefits. And it was a software company that the state was familiar with. And so she moved quickly under the state's emergency powers to get that contract approved and really focus on that solution. I don't know that there, from her perspective, there was a lot of time to consult with a lot of outside entities to help administer this program. The way that she had described it was trying to fly a plane while you're building it at the same time.
Understood. All right. Thank you. Please continue.
Sure. And so this slide here, just as an example of IT issues, this was an anonymous emailer who said that they had worked for Lorica, and this appears on page 158 of our report. And he was adamant that this was really an IT, a software-based issue that was causing a lot of the problems. And so, again, I can't competently talk about that, and I was unable to really get competent outside counsel on that from an IT expert. But if there were other areas of inquiry, and it's really the only loose end in the report itself, this would be the area where I would recommend the court take some time to look into. Common complaints that we discerned based on Appendix 1, this is reflected in Appendix 1, is that people initially applied for UI benefits at the direction of someone at D.E.T.R or Lorica. And
wait, hold on. Sorry to just stop you.
Yeah,
if that was the correct advice, why would that be a common complaint? In other words, if they still had an outstanding balance, and we know the law requires, or at least the state argues, and possibly persuasively to this court, that the law requires an exhaustion of the UI benefits, why would it be a complaint if they were directed to UI first?
Yes, Your Honor, because this puts the claimant in what we called here in the office the UI P.U.A. loop. And it's this kind of no man's land involving when you apply for benefits under the UI program and you're not entitled to them, and then you move into the P.U.A. program, and whatever information you've provided in UI and in P.U.A., there appears to be maybe some conflict, or not, there's not there's some flag placed on that as a result of being in that loop, and what it does is it delays a determination being made on the benefit for P.U.A. So they've done what they're supposed to do in UI. They move over to P.U.A. and then they're put in this no man's land because some flags were raised due to their prior application in the UI system. Again, I think that's maybe a software issue. It may be an issue of not having enough adjudicators to work out those flags. But it was a significant issue that came up in email after email, and that's why we gave it the name, the UI P.U.A. loop.
Okay. What are you referring to, cessation of benefit payments? Is it anything more than what it suggests, namely somebody was deemed eligible, apparently started receiving some level of benefits, then all of a sudden they abruptly stopped?
Yeah, that and most of these occurred on a specific date, which was kind of interesting. As to say, they were getting benefits, and then on June 28th, benefits stopped, and nobody really kind of had a good explanation as to why that happened.
Okay.
And then
reports of claims disappearing from the system. Even I understand what that means. What about bank payments being so large the bank rejected it? Isn't that a bank problem, not a D.E.T.R problem?
Well, it is and it isn't. So the bank rejects it, and then what has to happen is the claimant has to reach out to D.E.T.R and say, can you reissue the check because the bank has rejected it? I've cleared the issue with my bank, but now we have to have you reissue the payment, and they can't get through because the call center is overrun with other calls, and so they're having a very difficult time resolving a very simple issue.
Okay.
With disbursement of funds.
Okay.
The other issue is since May 16th, these individuals have not had any appeal rights.
That changed as of last week, did it not?
On Saturday they stood up the program.
Okay.
And then finally, extreme frustrations with the Lorca call center, and those are self-explanatory in the emails from the claimants themselves. And really, that's not only source of frustration, but it appeared to us reading those reports of the experiences with the Lorca that it was essentially putting salt in an already open wound for a lot of people who were suffering. And so I'll leave it to the court's judgment to review those and make its own determinations about that. But it was a real problem that took up a lot of the emails that we reviewed. In terms of the common themes and problems in the system.
Okay.
Putting that
how does Nevada compare to some of the other states, particularly those that are neighboring or at least in the West?
Well, as you mentioned earlier, there were some partnerships that states engaged in with the private sector that seemed to have been successful because they all faced the same crisis. So the same tsunami that hit us hit other states, maybe not as extreme. Again, Nevada is unique in that, our unemployment rate was historic, not just for Nevada, but was historic in terms of in the nation's history, there's never been a state that's cracked 30% unemployment.
Well, hold on. So if others were hit by the tsunami, Nevada, we were on a barrier island in the middle of the ocean when the tsunami hit. That's what I'm taking away from this.
Exactly right. And not only is Nevada hit by that, but all of Nevada's workforce is hit by this. And so the suffering we're hearing from the claimants as a result of this, and then the difficulties that these human beings at D.E.T.R are having administering the program are the result of this. But some states fix this, or at least address this issue by partnering with the private sector, as we discussed previously. Others utilize the National Guard because there is basically this influx of claims that couldn't be handled, and there were a bunch of flags with regard to fraud. And so the National Guard was brought in to help clear out those fraud flags, to actually confirm that they were dealing with real people and not with bots and other sophisticated fraud schemes. Other states used cloud-based online processes and call centers that seem to work out better in terms of the satisfaction of the claimants on the other end. We looked at states in our region: Arizona, California, Colorado. We also looked at states heavily dependent on tourism and gave you some context for what their experiences were. We asked some important questions. How are other states' unemployment divisions funded? And it's important to note that the state of Nevada's unemployment security division relies entirely on federal grants. There are no state funds that fund that agency. And so what that means is last year was a record for full employment. That is, the employment numbers over the last 2 years were at a record low for unemployment. And grant monies are determined by the number of claims that you process year over year. And so they were funded to the level of the claims that they had last year, not for the level of claims that they ultimately experienced this year. And so what that does is it causes the number of staff that are available to fluctuate and flow over the course of time based on demand. Other states provide a more stable foundation for their unemployment security division, so there's not quite that fluctuation with staff and professionals who are charged with delivering benefits. We also asked, how are other states dealing with the fraud issues? And there were
well, at least for Washington, not well.
Not well, yeah.
That the court understands that Washington was hit extremely forcefully by organized criminals who were set on and successful in taking advantage of the situation to the tune of more than $10 million. Is that factually borne out by what you saw, Mr. Guanasso?
Yes, Your Honor, that's factually correct. And these states all have the same obligations that that the state of Nevada has articulated and that the DOL has reaffirmed, and that is they have an obligation to monitor for fraud and to prevent fraud and to recover monies that are fraudulently expended. And this is not an easy issue, specifically with regard to the P.U.A program, because there aren't the checks in the system to that allow for, like, for example, if you were unemployed, Your Honor, and you stopped working at the court and filed unemployment, I could call the court and say, court, did Judge Breslow work for you from this period of time, this period of time? And the court would say yes. Well, for the P.U.A program, the people are 1099 independent contractors, self-employed people, and so the only means for confirming that they were employed is through self-attestation. And so there's some issues there, and other issues I can't really get into without the assistance of D.E.T.R in a private conversation, because there are ongoing investigations with regard to widespread issues in our state. And I'm getting up to the edge of talking about stuff that I promised I would keep confidential.
Yeah. Don't go over that edge. And for the record, I work for the people. I'm just employed by the courts. But okay, please continue.
And then we asked how quickly were other states able to begin accepting and processing claims compared to Nevada. Every state got their program up quicker than the state of Nevada. I think Nevada was the last one. But Nevada got to also benefit from some of the early experiences of the states, specifically with regard to the fraud issue, and begin at least trying from a systemic level to have processes in place to deal with fraud. And then finally, have other states' employment departments been sued? Answer is yes. One of those lawsuits in Florida was dismissed. Another one is in Washington, is pending. So there are other lawsuits in other states that look a lot like the one that's in front of you.
All right, and then let's go back though to would you please go back to that slide? Yeah, under letter V for Victor, or Roman numeral 5, how quickly were other states able to begin accepting and processing claims? Now, I've seen a little bit of information that expands on that. I mean, the simple fact appears to be that Nevada was the last one to stand up its website, and maybe I have that wrong and the state can correct me. But in terms of the timing of starting to actually pay claimants, I believe Nevada was not last and possibly more in the middle of the bell curve. And in terms of, as the state emphasized at the last hearing, in terms of payment per applicant, Nevada is in the top 10. So, that's fact, but the entire perspective on that issue, I'm expecting the state to make sure the court is informed of their view. All right, please continue.
Yes, Your Honor. And that data that you're referring to, we actually include in the data analysis a couple of sections ago when we're dealing with the P.U.A statistics, so that we can figure that out in other sections of the report.
Mm-hmm.
For the court's edification, I thought it would be important for you to understand what the disputed versus undisputed facts were, at least to try to get down to where the real disputes were. I didn't do a lot of time editing that or trying to call out the specific disputes, but I leave it to your discretion. I thought it would be a helpful tool for you.
No, I reviewed the entire thing, and it did crystallize in the court's mind the overlap on issues that were genuinely agreed to, but of course the areas in which no agreement was reached.
Yeah, I thought that might be helpful to the court, especially in this short time frame, trying to get down to what the real disputes are. As I mentioned earlier, I had the opportunity, due to the cooperation of the Department of Labor, to ask them I got one shot to ask questions. And I put together a list of written questions, submitted to them. They got me the answers within 24 hours.
No, I was extremely impressed. The mere fact that they would engage, the level of their engagement, the comprehensiveness of their responses, and the clarification on the Department of Labor position on issues that could arguably have been in the gray area. So I thank them for agreeing to work with us, and good call for reaching out to them and seeing if they would respond, because they did.
Yeah,
But go ahead and let's not go through each of those. I don't know if you have any. What are the specific ones? The Department of Labor. What if you said, Judge, these are the three most important answers in your mind to what the DOL said? Do you have those sort of handy, or is that for the court to review and determine on its own?
Your Honor, for the purpose of this presentation, I really leave it to the court's discretion on what to focus on, what not to. I thought it was important to at least reach out to the DOL to understand what options might be available to the state.
Well, let me make sure I'm clear though. The court recalls very vividly the Department of Labor responding that a claimant with unemployment insurance benefits available cannot waive those benefits in lieu of directly applying for pandemic unemployment assistance benefits. And so it's not waivable. And so that's something we're going to have to deal with here further as part of this hearing. But
yes,
Mr. Guanasso, did you read the response any differently than the court just did?
I did not. And that was one, and you could see from the questions, I tried to hit that from 3 different angles to see if there was any flexibility.
No, you did. You said, what's your position? And they said, and then you said, are you sure? And they said, we're very sure. And you said, are you double sure? And they said, we're quadruple sure, Mr. Guanasso. You must, tell Judge Breslow. I mean, they didn't use those terms, but the clear gist of it was it's not waivable. You need to move through that program fully and completely before you become eligible for P.U.A. benefits. But again, that doesn't end this hearing because of that answer. It just begets the question of whether the state is abusing its discretion or acting arbitrarily and capriciously in the manner in which it's moving people through the UI system so that they can then get to the P.U.A. system. So we're going to talk about that in a little more detail shortly. Okay, what else?
And then the one thing I would note too, and this is maybe for plaintiff's benefit or petitioner's benefit, is that just because the DOL says that and agrees with D.E.T.R's position doesn't necessarily mean that the DOL is reading the statute correctly. There is some argument to be made as to what the statute requires with regard to basic eligibility for P.U.A. benefits and what the DOL and states are requiring on top of that. But I'll leave that to the court. That's legal analysis. It's not facts, but it was something we noted in our report for your consideration. The next thing I did is I presented the court's questions to D.E.T.R to just give short answers based on all the context. So I've moved down the funnel, given you all the background information. Now we can answer your questions in specific context, and the answers I think speak for themselves. I then had a number of questions, as you could see, of D.E.T.R, and they provided a number of responses. One response I wanted to highlight for you that may not have been as clear, but is important is—
What page is that, please?
273.
Okay, go ahead.
So on 273, what I asked for was something like an aged accounts report. As a managing partner for a firm, when I'm looking at receivables, I want to know how long has it been since somebody's paid me? And so I have this report. And so I asked them, hey, do you have something like an aged accounts report? So I could look at all of the accounts and see how long they've aged, who hasn't been paid, that sort of thing. And we had talked about that, Your Honor, as something that you wanted, some robust data to look at.
Well, the problem is the amount of people that we're talking about, the information, just to input that data and keep it updated it seems to the court would have been an extremely monumental task, particularly on short notice, if it doesn't already exist.
That's true, but Chief Economist Schmidt really worked hard at that and got us something. And so if you look at the bottom of page 273, right here, you'll see, geez, my pen is going crazy. Sorry about that. Right here,
yes,
you'll see
the link.
A link, and what this has in it is essentially an aged accounts report. And what we tried to do is each of the files, and there's over 3,000, there's several, it would have been a 3,000 page document. So I didn't print it, but it has the claim file, it has the weekly certification, the issues, and really it would be, if this court were inclined to try to drill down deeper into this issue on a claimant by claimant basis, this would really be the starting point for that, and really kind of the foundation for what do we need to do to this is the foundational data in my mind that what do we need to focus on as the most urgent. Like there are a number of claimants that have said in their reports to us they haven't been paid since the beginning of the program. That report would allow us to really prioritize the people that have been waiting the longest and work our way backwards. I also asked the petitioner some questions. Some of them, the written questions I had for them were not, as important, to include in the report. They were just, things, the clarifications regarding their clients and different issues.
Their responses to those, while helpful, they essentially re-argue their position of what they think the court should do, what the law they believe requires, and some of the failures of the state to do what the law otherwise requires of them. So they were more argumentative and less informational, frankly, with respect to those responses.
Yeah, and I thought it would be helpful though to know, like, what ultimately does the plaintiff want to see, in terms of a fix? What are the
they filed their supplemental motion late last week. That's what they want. At least that's the court's understanding of what they want.
Exactly. Well, let me cut to the chase then, and just the bottlenecks is outlined on page 290 of our report. Really, there's no opportunity for a aggrieved claimant to challenge D.E.T.R decisions or non-decisions. Of course, that did change as of Saturday. The unemployment insurance system was not created to handle hundreds of thousands of claims in 90 days and establish a new benefit program to serve additional people. The system wasn't created for this, and the people weren't in place to do this. This is all happening real time in a very rapid way, and so a very difficult situation for all involved. The widespread existence of glitches in the benefit delivery system, I talked to you about that. Claimant errors are rampant, which led to significant delays in processing and application. People, notwithstanding the user interface being user friendly, there's still answers given and information provided that created flags. And usually, under normal circumstances, you can clear those flags relatively quickly. Under these circumstances, a lot of times those flags took weeks and weeks and still aren't resolved. Claimants do not have a reliable person who can provide them with information and assistance to accurately complete applications and resolve problems as they arise. So there's nobody you can just call and say, hey, I run into this problem, or I don't understand this question. Can you help me kind of complete this because I'm confused? Nothing really like that to help somebody under these circumstances.
Well, there's no single ombudsman or ombudswoman who can be the person you call when the other approaches aren't working properly. It's unfortunately not that type of a problem that the state is encountering and that the applicants are encountering.
That's exactly right. And the state did hire a call center that was really supposed to do this, but the call center hired to answer questions and provide assistance really, has failed consistently to deliver competent and compassionate service. I mean, and I can only base that on the thousands of emails that we receive from claimants. One of their biggest frustrations is dealing with a call center that doesn't have the answers to their questions and doesn't seem to empathize with their circumstances. And so, and the part of that is they were brought in and onboarded with about a day and a half's worth of training. Of course, as they've been with in the Nevada system for a bit of time, Administrator Goss said that they've been provided with supplemental training. But you can imagine if you're trying to pay your rent, Your Honor, or if you're about to lose your car, if you're trying to feed your family, that the call center that you call over and over and over again, and you finally get through as if you've won the lottery, and you think, great, I'm gonna get my questions answered, and then they don't have answers to your questions, and then they're rude to you to boot. I labeled that as cruel. I'll leave it to your discretion to determine whether my assessment of that circumstance is correct or not. The new benefit programs are vulnerable to fraud. I spoke a lot about that already. And then the systemic fraud really has constipated the system. When you have systemic fraud, they had to push the pause button. And so you got a lot of people who were captured in this kind of fraud flagging. And it's taking a while to unwind that whole process, which again, other states have dealt with that by bringing in volunteers. In Hawaii, they brought in volunteers. In Oregon, Washington, they deployed the National Guard. So there are ways to deal with that in a way that expedites the payment of benefits. Based on those identified bottlenecks, Your Honor, as you saw in my report, I said that there really has to be a P.U.A appeal process. And I know that the process was stood up on Saturday, but if the court is so inclined, I think staying engaged to make sure that that system actually provides the due process that they're entitled to under our Supreme Court precedent and under the statute, I think would be very important. I presented a proposal based on what other states have done. I called it the Emergency Volunteer Claim Concierge Corps. And this would be a group of volunteers that within 45 days would help the department go through the backlog and clear out flags and get people paid their benefits. This has worked in other states. It's not something I just thought of on my own. It's worked in other states. I've talked to individuals from one end of the state to the other who said if they were asked to put together volunteers. I've talked to labor union reps. I've talked to church representatives. I've talked to civic organizations. I even I spoke to D.E.T.R over the weekend as we were kind of massaging this option a little bit to see, to address some of the concerns about how to implement something like that. But if we're going to deal with the immediate crisis and backlog, D.E.T.R needs help, and they don't have any money to hire more people. Like other states face that same problem. They said, this is a crisis. We need to help our neighbors. Let's handle this either through the National Guard or through getting competent people to volunteer to help.
Okay. I'm surprised you didn't identify, for example, possibly UNLV Boyd Law School students or something like that who might want to engage at that type of endeavor. All right, what else?
And then the call center needs to improve. The contract can't be canceled, but there's certainly the state under that contract, as I reviewed it, has a right to demand a certain level of service and competence in delivering that service. And so I put that in there as an important thing that has to improve immediately, because it's one thing to suffer as a result of the economy. It's another thing to suffer as a result of feeling like, one, you're not getting your questions answered, and two, the people on the other end of the line don't really care about the fact that you're going to lose your home or not be able to feed your kids. And then due process, finally, I think cures a lot of fraud issues. And so I left my analysis in the report for you to consider with regard to how due process could help alleviate some of the fraud issues. and hopefully it will, as this new program is stood up to allow for appeal rights. But the lack of due process is an injury in and of itself, as the court, as our Supreme Courts have said. And so I wanted to highlight that injury and highlight not only how it impacts individuals, but how lack of due process actually impacts the system and injures the system, because it's not able to function to weed out fraudsters like it's designed to do, or like it has the opportunity to do. So with that, Your Honor, I took way more time than we agreed to get through that, but I hope that you found that this summary was helpful to you. I hope that the parties found this helpful. I want to thank the parties for cooperating from day one, getting me all the information that I needed. It was a real collaborative effort, and it was the result of everybody good faith participation.
Thank you. Here's what we're going to do. Court's going to be in recess for about 5 minutes. At that, when we come back, Mr. Thierman, please be prepared to make argument to the court as to what you believe the status is of your petition in light of the factual findings of the special master. After that, I'll hear from the state, essentially with the same questions. Either side, of course, can respond to any of the comments that the special master just made, any of the findings that he's presented. So you're not limited solely to making argument with respect to the briefing you've previously filed. After that, we'll have some further discussion and the court will make a decision here. We'll be in recess until 10:20.